just to let you know the order they're going to take it in. I've marked them. Document 1 is the order, document 2 is the letter, and document 3 is the notice. I mean, they'll probably bring it up, but they're going to take them in that order.
Okay. Thank you very much.
Yes, Mr. Hyde.
Good afternoon, Your Lordships. I think you have in front of you, and hopefully you will have had a chance of looking at, firstly, a proposed order consequent upon this second hearing, if I may call it that. Secondly, the text of the proposed revised directions hearing letter. And thirdly, the text of the proposed revised direction notice to all parties.
Yes, we have those, and thank you all for all your hard work since this morning.
If I could also just pass up two more bits of paper. One is the original and one is a copy of the further witness statement that Mr. Wilde has now sworn.
Oh, sorry.
One of these is the original.
That looks like good.
I'll leave the original. So in terms of, if we can deal with that issue first, I think that's pretty straightforward. So the order now also recites the fact that the court has read the second witness statement of Mr. Wilde,
yes,
and which I think means that the first paragraph of the order, it is found that the applicants have complied with their obligations, can now be made in the appropriate terms, assuming, of course, you're happy with that statement.
Yes, thank you. Incidentally, I should have mentioned that we received your copy of the, I'll call it the first order, and what's the most of that time is that although the rules require that orders should be timed as well as dated, that hasn't in fact been the practice in the past. or wasn't when the earlier VAN hearings took
Right.
place. But clearly we should do that, and therefore the first order has got final issue. I think it was 2 p.m.
At 2 p.m. I see that from the order.
When we come to this order that we're now looking at, I think we feel that just to have this as order and the same date, even with a different time, it's strictly accurate, but it would be helpful if this one was headed second order.
The draft, yes, understood.
It's all a bit inelegant, but that at least will make it clear that this is the second order made on today.
Indeed.
Good. Well, now, the one point which my Lord wanted to raise on the second order was that you don't actually give the date, any order as to the date of the directions hearing. And we wondered whether that ought not to be included as an express order.
A very good point, if I may so say.
Yeah. Well, as I've made plain, it wasn't mine, it was my Lord's, but I think we felt that could be, by simply adding a paragraph 5, the date of the directions hearing shall take place, it's pursuant to Article 12, isn't it? On
I wonder whether we should strictly make that a new paragraph 4, because the previous 2 paragraphs are dealing with the directions hearing.
Yes, right, as you think fit. So make that 4, and new 4, and then old 4 becomes 5. And the date of the directions hearing shall be
2nd of November.
2nd of November. So, and ex abundanti cartilla, put in brackets, subject to further order.
Date of the directions order to be held pursuant to Article 12.
Yeah. Date of directions hearing to be held pursuant to Article 12, Section 1 of the schedule, Section 2 of the schedule, shall be the 2nd of November 2017, brackets, subject to further order, if any.
Yes, indeed.
The directions hearing
The directions hearing, yes.
to be held pursuant to Article 12 of Schedule of Section 2 to the schedule to the decree. Shall be held on 2nd of
Shall be the 2nd of November 2017, bracket, subject to further order, comma,
If any, yes.
Well, will you prepare a fair copy for me to sign?
I certainly will.
Thank you.
Do we need to go through these?
Subject to further order,
Order, comma, if any.
if any.
I think in a different context, my Lord and I were thinking it's best not to cast doubt on the date of 2nd of November, because it begins to make it look a bit more flexible
Yes.
than you want it to be.
No, indeed.
Because if the court were persuaded to make an order for a different date, it would have to include in that order provisions for everybody being told that that was a different date.
Indeed, not least because the appropriate notice would have to be given
Yeah.
to interested parties.
Yeah. So that's the form of the order.
Do I need to take you through the changes made to the draft letter and notice?
You need to take us to changes not made in the draft order.
Well, we're now going on to document 2.
Yes.
Yes. So should we look at that first? My Lord has some points on that.
This is the directions hearing letter.
Yes.
Now, when we get to paragraph 21 of the marked up copy, which recites that the CVA companies have made applications for a directions hearing for the purposes of A and B,
Yes.
that would be the appropriate point at which to state the tribunal has directed that the hearing be on 2nd of November. Because there's a gap. You then go on, notice is hereby given that the hearing will take place on the 2nd of November. The only reason why you can give such notice is because the court has ordered that it should be.
Yes, indeed.
So I think you want at the end of 20, either a new paragraph or perhaps at the end of 21, the tribunal
Has directed.
pursuant to such applications or in response to such applications. The tribunal has directed, has ordered that the directions hearing be held or be fixed for 2nd November 2017. And then you can start paragraph 22 with the words accordingly, comma, notice is hereby given that the directions hearing will take out the words now. Accordingly, notice is hereby given in the form of this letter that the directions hearing will take place on the 2nd of November 2017. And I wouldn't include all such later time as the tribunal orders, because that injects an element of uncertainty which is unnecessary at this stage. Yes. That's the first point. The second point is under the paragraph, the action you should now take. You've got the text.
Yeah.
Yes, you've got it.
Well, these are the points as noted. Paragraph 42, a small point, that concludes, will be drawn to the tribunal's attention at the directions hearing, but we suggest you put in at or before, because as you will see from what I say next, we want to emphasize that notice ought to be given in advance as soon if at all possible.
Yes.
So that simply say at or before. Then when you get to paragraph 43, run through to the end of the first sentence. That's giving the address of the courts. And what follows is concerned if you do intend to appear, and that can become 44, this is what we suggest, but add to 43, which is still concerned with if they about the hearing. And I'll dictate this so that you can note it down and then consider it. This will be an additional sentence in paragraph 43. Or do you want a new paragraph, John?
No, I think it can. I think it comes in as the
After
second
the address.
Yes, yeah, yeah. Quote, you should be aware that if you fail to attend the directions hearing or to raise any concerns or issues before that date, I think we should say, you should be aware that if you fail to attend the directions hearing or to raise any concerns or issues before that date, comma, the applicants will oppose any attempt you might make to raise them subsequently or to challenge the directions made at that hearing. I'll read it through once when you're finished. So the complete sentence would read, you should be aware that if you fail to attend the directions hearing or to raise any concerns or issues before that date, the applicants will oppose any attempt you might make to raise them subsequently or to challenge the directions made at that hearing.
That looks very good to me. The only minor observation I have is, could we change applicants to the CVA companies, because that's the definition we use in the letter.
Right, that's right.
Yes.
Yes, okay. And so that, if that becomes the second, and by all means take time to consider it, but I'll just give you the last suggested amendment. What follows, beginning, if you do intend to appear, becomes paragraph 44.
Yes.
And we would suggest you add to that, if you could give prior written notice of the matters you intend to raise, insert both to the tribunal and
to the CVA companies or their legal advisors. Yes.
we thought it might help if at least we were told, even if you were going to forward it later. But
Understood entirely.
so that, and then 44, present 44 becomes 45. So, is there anything you'd like to say about specifically the new added sentence to paragraph 43? Paragraph 43.
That's good. Thank you very much.
Are you happy with that?
Happy with that, yes.
Good.
Can I just suggest a slightly simpler form of wording, because it's not enough to attend the directions hearing and say nothing. Perhaps we should say, you should be aware that if you fail to raise at the directions hearing, at or before the directions hearing, you should be aware that if you fail to raise at or before the directions hearing any concerns or issues relating to the
If you
directions
fail to raise any
sought.
concerns or issues at or before the directions hearing.
Yeah, at or before.
You bring the reference to concerns and issues forwards, right?
You should be aware that if you fail to raise...
If you fail to raise
directions hearing,
any concerns or issues at or before the directions hearing, the CVA companies will oppose any attempts
Any concerns or issues relating to the directions sought?
Relating to the directions sought. Yes. See if I can somebody might make to raise to challenge the directions made at that hearing. Yes?
So, are you happy with that, John?
Yeah.
Good. Well, and now just, I think, one point on document 3, which is the notice to non-CBA parties. Paragraph 4. There are 2 points. This is the first one. If you're not a lender or an equity interest holder, the directions hearing has no impact whatsoever in respect of your existing claims or interests. That seemed to us to be an unnecessarily wide and, so to speak, dogmatic statement, because if one of these people were to come along, it would be on the basis that the proposals were prejudicial to them. And that's right, isn't it?
Sorry, your Lordship's envisioning a scenario in which somebody who's not one of these parties nevertheless wishes to be heard on the directions hearing.
Yeah.
Because wishes to assert that the directions do affect them.
Yes, I mean, I guess what I'm struggling with is because I think we are all clear they do only affect the impaired creditors, and it's very clear that if you're not within that class, you're not impaired. I'm struggling to see how somebody could turn up and say they are impacted by the directions.
Well,
or would have a right to be heard.
We suggest that instead of the words has no impact whatsoever in respect of, you have the words should not have any impact on.
Yes.
So it
Yes, because what we were obviously trying to deal with was the slightly different point made this morning, that the letter was somewhat verbose. If you were an affected party, and if you were an affected party, you would receive the full notice anyway.
Yeah.
So this was trying to make it clear, if you're not an affected creditor, you really don't need to read on any further.
Yes. Well, anyway, that's what we would
Yes.
prefer to see. If you're not a
Whole of the directions hearing should not have any impact on your existing claims or interests. Yes?
claims and interests, I think.
Claims and interests, yes.
If you're happy with that, then the end of paragraph 5, you've got 84%. Should that be 88%?
You're quite right, we corrected it in the...
And finally, at the very end, paragraph 8, this, I found this difficult to understand at first reading, but my Lord is correct, or shown me, it's meant to cover 3 things, isn't it? The other creditors are not impaired.
Yes.
2, they will be conclusively deemed to have accepted. And 3, they will not be invited to vote. And I think if you were to insert the word they twice, the first would be after the comma after decree. That's the second item. And again, they will not be invited.
Yes.
But those were our only points. That's right, John.
Yes.
Yeah. Those were our only points on those documents.
Thank you for that. Can we now just revert quickly to the order?
Yes.
And make sure that we're hopefully all agreed on the form of that order. The first point is noted that it needs to be marked second order.
Yes.
I think we've dealt with the first paragraph under it is found that. For paragraph 1 of the operative order,
I'm just going to be finicky about this. I think if we say second order brackets dated, what we're really saying is it's the second order made today. So if you say second order dated 3rd of October 2017.
yes. So in relation then to paragraph 1 of the order itself, we will need to attach to the order the form of certificate that we looked at earlier, and we will just amend up that soft copy so that it bears today's date, etc. And then it can, not only can it then be attached to the order, but the separate certificate itself can also issue today as well.
Will you need the actual document to be part of the order?
Well,
Oh, it does say in the form attached.
in the form attached, so it will be attached as a final draft, but then we'd like the certificate signed and sealed separate.
Right, yes.
Then, in terms of paragraph 2, I think we've covered all of that, and at the end there it's noted that we say the directions hearing letter is in the form shown at the relevant part of the exhibit to Mr. El-Kasabi's witness statement, as subsequently amended at the direction of the tribunal, and therefore in the terms that we have discussed this afternoon. And the same point applies to paragraph 3. Then, as discussed, we will have the new paragraph 4 dealing with the direction of the actual date of the directions hearing itself, the 2nd of November. And then paragraph 5, I just want to be clear that following this morning's discussion, when we were looking at 2 provisions, we have successfully now reflected the agreed position in the form of this one paragraph, which only deals with Article 30 of Section 2, doesn't reference Section 15, and makes it clear that we're talking about obligations existing as at the 2nd of October.
Yes. And that covers all the points you've made.
That covers all the points that I needed to make and that need to be covered in the order, in the second order. So unless there's anything else, we will...
Yeah, that's right. We can time this 4:30 p.m.
Excellent, and we will deliver that, the final form order and certificate, as soon as we can, so that those can be signed off before perhaps people depart this afternoon.
Yes, well, I'll stay here so that I can sign.
Thank you very much for watching.
Good. Well, the second order will be in that form and timed at 4:30.
Thank you. Thank you.
Well, thank you very much indeed. And we're now committed to meet at 10 o'clock on the November the 2nd.
Indeed.
Subject to any further order, if any.
And it will be interesting to see whether I'm joined by anybody else that day.
Right. Yes, of course.
Thank you.
All right.
Thank you very much.